Hi, my name is Jen Connolly, and I'm an MBA student at Loyola Marymount University. I've put together a presentation regarding the ethical limitations of email privacy. I hope you enjoy. With the advances in technology these days, the privacy line keeps getting blurrier and blurrier. One can almost argue that it has almost disappeared. As Alex Kaczynski, the Chief Judge of the U.S. Court of Appeals for the Ninth Circuit, so eloquently states in an editorial he wrote last month, we're working on a eulogy for the Fourth Amendment, the part of the Constitution guarding against unreasonable searches and seizures, in effect a privacy provision. Via technology, consumers have put a knife in it by letting supermarkets track your shopping in exchange for loyalty discounts, letting Amazon and eBay store your credit card information, and letting Google track the websites you visit and take photos of your homes with satellites. You see, the Fourth Amendment only protects things that we haven't already revealed to other people or to the public. That being said, where does email fall on the privacy line? One could argue that since you are making record of your thoughts and intentions via a written document, such as electronic mail, and sending it through an internet provider service, you are consenting that it is public, sharing it with the provider, a public server, and with whomever you are sending it. However, one could also argue that since it is password protected, your email is private, just like a sealed envelope would be considered private and therefore punishable if unlawfully opened. Let's consider all the newsworthy scandals, both serious and comical, that have been uncovered via email exchanges. I'm sure anyone that works in a corporate setting has heard of a workplace affair uncovered by email history of the employees. Somehow, throughout history, society has defined other forms of communication, such as written letters and phone conversations, as private, but has considered email a public source. Why is this? Think about how it differs from older forms of communication. There's the immediacy, of course, but there's also the simplicity of archiving it. One's desk drawers don't have to overflow with old correspondence. It just sits there on your desktop or in your organization's backup files, waiting for someone to search sex or secret, and bam, you are discovered. And as it travels across the internet, it often does so without encryption. The old saying about an email being like a postcard that every mailman can read has an element of truth. Here's another way in which it is different than older forms of communication. There's an implied letterhead on every email sent from a company or organization, that little trailing domain after the @ symbol. If you send an email from an army.mil domain, you are sending an email from the Army. From foxnews.com or from newyorktimes.com, those emails can be interpreted as though you are acting on behalf of those companies. And shouldn't those companies have the right to your emails then? Who should have the right to your emails? Certainly the people you are sending them to. But should they have a right to forward, print, or otherwise publish your email then accordingly? Should the internet service provider have the right or even responsibility to access and retrieve your emails when asked by, say, a court of law? Should your emails be able to stand as evidence in court? Should lawyers be able to use email as a confidential means of communication? Worse yet, what do we do about hackers? Certainly their actions are malicious and unlawful, but as emails become less and less private, hackers are given more avenues to unveil them. In June, Google announced that hackers in China had gotten access to hundreds of Gmail accounts, and it wasn't just anyone's email. The attack targeted senior government officials in the United States, Chinese political activists, officials in several Asian countries, military personnel, and journalists. If that's not scary, I'm not sure what is. And then there's the issue of email tracing or tracking. According to Wikipedia, email tracking is a method of monitoring the email delivery to intended recipient. Most tracking technologies utilize some form of digitally timestamped record to reveal the exact time and date that your email is received or opened, as well as the IP address of the recipient. Email tracking is useful when the sender wants to know if the intended recipient actually received the email or if they clicked the links. However, this again blurs the privacy line significantly. Email tracking is used by individuals, email marketers, spammers, and phishers to verify that emails are actually read by recipients, that email addresses are valid, and that the content of emails has made it past spam filters. It can sometimes reveal if emails get forwarded, but not usually to who. Some companies use it at the aggregate level to help determine the effectiveness of their sales and marketing messages, and some companies use it at the individual level to better understand a customer's specific areas of interest. So which of these cases are ethical? They are using the same technology, but should the practice of the technology be considered lawful or unlawful? The discussion regarding privacy of emails and the ethics of using information mined from its contents is not a new one, and the basis of the discussion expands into other new technologies such as BBMs, texting, Facebook, Twitter, GPS, etc. My question to you is, how far does technology have to advance before our privacy line completely disappears? Thank you. That's the end of my presentation. I hope that you enjoyed it, and I just wanted to say thanks to all these great sources for helping me gather my thoughts on this topic. Thanks.